The leaseback repurchase scheme. There have been a lot of these in Florida. And this is where they convince the owner to go ahead and deed the property to them, which is great. They no longer own the property. There's a promise that they'll be able to live there. But if that doesn't involve them also paying off the mortgage, the homeowner is still obligated on the mortgage, and they've given up all of their right, title, and interest in the property. And often the repurchase piece of it, the terms are so difficult that the person is never going to realistically be able to get this property back. The other pieces of it, they don't pay the mortgage, or they evict the owner as soon as they get title. On some of these properties, people are upside down. They don't have a lot of equity. They bought at the height of the market. There isn't much equity in the property. But some of these, people have lived in these homes for a while. They're encountering hard times. They do have substantial equity, so there's some real value that's being lost when they deed the property over. The refinance fraud, the bait and switch. This is where the rescuer pretends to be a lender or a mortgage broker. And they have the homeowner sign numerous documents. The owners believe that they're refinancing the property under more favorable terms. And either in the stack of documents, there is some language of conveyance or an actual deed. And the people don't know that they're actually tendering title to the property until after it's done and over with. And they no longer own the property than they are in the process of being removed from the home that they formerly owned. Bankruptcy scheme is where the owner consents to deed the property to multiple parties. And in a bankruptcy proceeding, there's a protection called an automatic stay, which means that your creditors can't pursue you legally for your debts until the stay is lifted. So there's A, B, C, and D owner of this property. And in succession, they all start declaring bankruptcy, but eventually that trick runs out, and the people are once again have been taken for their money, and they're going to be displaced from their home. They're out, and the property is eventually lost in foreclosure. We will buy your house. This is where the rescuer comes in and promises to find a buyer for a distressed property. But the owner has to deed the property to the rescuer first. And you can just imagine that, these are con artists, so they're very savvy. And so you're saying, normally I wouldn't fall for that, but there are pros out there. And they may tell you, oh, well, we've got somebody waiting in the wings. They need to remain, for tax purposes, they need to have their identity remain anonymous, or whatever spin they put on it. Once that deed is out of your name, you've lost the property. They either retain the property and never pay you any interest in it, or they sell the property and give you none of the proceeds because you have no interest in the property anymore. You've deeded it away. Do's and don'ts. And this has been covered already, but I'm going to go over it briefly because you cannot hear this too much. Do contact your lender directly. Make your mortgage payments only to the lender, not to a third party, not to a rescuer, not to anybody who claims that they're going to make these payments for you. You stand an awful big chance that they will not. Seek the advice of an attorney before signing any legal documents. Anybody up here was happy to look at, legal documents. I'm happy to do that if somebody's in a situation. There's so much less that we can do to help you after it's been done, after you've signed away interests. Get everything in writing and fully understand everything that you are signing. If you don't understand it and it can't be explained to you, then you need to not sign it. Don't sign a deed conveying title to your property unless you fully understand what the terms are. Don't sign any documents with blank lines. Never sign a contract under pressure. I know that seems a little ironic under the situation, but and don't believe anything that sounds too good to be true, because it probably isn't. There's a recent case that came down, and I point this out to realtors and to those of us who work in real estate, and there may be some title agents out there. The case of Charles versus Florida Foreclosure Placement Center. Mrs. Charles was an elderly lady. She'd owned her home for many, many years. She had a first mortgage and she had a second mortgage that she got later on. She started to fall behind in the mortgages, and foreclosure proceedings were commenced against her. Somebody saw this, obviously saw a public notice, somehow got wind of this, one of these rescuers, and they stepped in and said, we'll help you, Mrs. Charles. We'll refinance your property. And in the process of this phantom refinancing, she signed away title to the property without realizing that she had signed title away to the property. And she sued everybody involved, including the title company. And the court came down and said, to be a co-conspirator, you don't need to know the entire scheme, but you only need to know your part of it to be held liable. And they said that it was negligent for the closing agent to fail to identify each document that the borrower was signing. And that's a very strong strong statement and a strong position for the court to take. So beware. If it seems fishy, ask questions and don't be on the hook. You don't need to be sued, because I know it's hard out there. There's not a lot of work. It's slow even for real estate attorneys, and it's slow for title companies and realtors. Don't get yourself in the middle of a fraud situation, because you'll be held liable for it. But thank